Good afternoon, ladies and gentlemen, and welcome to this Give Me 15 Minutes education program for medical professionals. My name is Jennifer Steerfoss, and I am the CEO of the Steerfoss Consulting Group. This presentation is covering what you need to know about the HIPAA Notice of Privacy Practices. This is a live session that's being recorded on March 20th, 2013, and will be available for free through iTunes as a podcast or as a video archive with handouts on jensteerfoss.com. One quick legal note. None of the information contained in this presentation should be construed as legal advice. I encourage you to contact counsel if you have any questions regarding state or federal law that apply to the concepts covered in this session. At the end of this presentation, I will cover your questions. Please submit any questions that you have in the question box, which is located on your screen for those that are listening live. With that, let's go ahead and get started. This is a brief session, again, for 15 minutes, and I'm going to cover a number of things rather quickly. The first item that I'm going to cover is really what is a HIPAA Notice of Privacy Practices. I'll give a brief overview of the HIPAA Mega Rule. I'll go over the new requirements, and then we'll cover your homework on what you need to do. So with that, and I'll make sure that I can get my screen back here, let's go ahead and get back and down to business. So the HIPAA Notice of Privacy Practices is located in the Code of Federal Register, and it was actually part of the original HIPAA legislation that was passed way back when. And one of the things, again, to keep in mind is that it is a written notice, and it needs to be posted and distributed by all covered entities about what your privacy practices are, basically how you're going to keep information private and how you're going to deal with disclosures and other things. Now, just as a quick refresher, the covered entities are, again, this is folks that are getting involved because of electronic transactions, and that's actually how HIPAA gets involved with everyone. But this does include medical professionals, physicians, hospitals, other healthcare professionals, but also clearinghouses and health plans are considered covered entities. And when it comes down to the Notice of Privacy Practices, it does require you to have an interactive and face-to-face encounter with a patient. And that's when the notice encounter does require, that encounter requires the notice to be provided. So just as a quick refresher, if you haven't already heard about the Mega Rule, this is something that many of us were looking for, and I can tell you all over the fall and winter I was anxiously awaiting this Mega Rule. It includes 4 different final rules that become effective March 26th, so just in a week. There's a couple of requirements that are of particular note for March 26th implementation, but specifically, you don't need to worry about it as a medical professional or medical administrator until September 23rd. I won't get into those. But again, this is a Mega Rule that includes 4 different regulations related to the implementation of high-tech, but also some of the other things that were included in the American Recovery and Reinvestment Act. So with that, let's get into what the requirements are in this new Mega Rule. And so there are some changes related specifically to the Notice of Privacy Practices, and I've got them outlined here. The first one is that you have to affirmatively state that by law, you as a medical practitioner and your office is required to maintain privacy and provide notice as a legal duty. And this is actually just a simple sentence that you can weave into your practice, usually early on into that notice. The second one, though, is that you do have to explain that you're required to notify the patient if a breach occurs. So if there is a breach of private information, you have to tell the patient that their information has been compromised and that there was unsecured protected health information. So for example, let's talk about a breach. A breach could include where you send a, let's just say it's a bill and it goes to the wrong address, and that bill includes their name, the type of services that they had, and their address. That is protected health information, and you need to contact the patient and let them know that that breach did occur. Now, obviously, there's different levels of breaches, and that will be covered in another session entirely. But again, the breaches out there, if something does happen, you need to provide notice. And in the Notice of Privacy Practices, you need to provide notice that you are going to tell them that a breach, if it did occur, that it occurred, and obviously what you're doing about it. The last one, and this is, again, some interesting things and nuances, has to do with how the uses and disclosure of patient information is going to happen and what requires a an authorization for the patient's information to be disclosed. The way I think about this is that a patient right now really doesn't understand what type of information can freely go out without their authorization, so treatment, payment, and other healthcare operations. Well, we know what TPO is. Most patients don't. So instead, again, in a user-friendly way and something that makes sense to a patient, you need to explain that, you know what, if we do certain types of disclosures, we're going to have to come back to you and we're going to have to get your affirmative authorization that you are going to share this information. So for example, for marketing, let's say that you've got a relationship with a pharmaceutical company. And so let's say it's for a diabetic type of drug. And so what in that instance, if there was going to be marketing outreach by the pharmaceutical company for that drug, you would have to go into all of your patients with diabetes or pre-diabetes and then go and get again, that authorization that would allow that information, that their information be shared with the pharmaceutical company. So again, that type of example, really being clear to the patient, is helpful for them to understand that, no, this isn't going to be something that's posted out. Also, it's not something that you're freely disclosing to third parties unless they are intimately related in, again, either the payment or the treatment of their health care. So one of the other things that came up, and I'm sure that there's a reason and rationale for it, but fundraising. So let's say your office was doing a fundraiser. Again, that would require a patient authorization for their information to be used for fundraising purposes, and that the patient may opt out. My guess is that this is part of a nonprofit hospital fundraising effort, and so that's why that is involved in, but that's my best guess. The last one is that, you know, a patient might say, you know what, I don't want my information going out and being disclosed at all, specifically even for treatment and payment. But you know what, that's something that you don't necessarily need to comply with, especially if it's related to treatment. Unless, and there's this one caveat, if the patient pays completely out of pocket, they pay 100% out of pocket, they actually can have a restriction on the information being disclosed, and therefore it's not shared. So probably the best example is, let's say a patient's really worried about any stigma or any implications that could come from having a HIV test, for example, and they pay for that HIV test completely out of pocket. They don't want it to go to the health plan because that information will end up in a database that's used for resetting their rates for health insurance, but likewise, they don't want other physicians to know about that for whatever reason, and obviously for sensitivity related to other patients' personnel and possibly their family as well. So again, something to keep in mind, but that's not something that you have to follow, and again, they need to have notice of that. So giving notice is always a pain in the tush, and I know that it's actually rather interesting what has happened. Health plans are not being given as much flexibility, if you will. They're given some more flexibility in a different way, which I wish that actually providers had. But a couple things to note. So the Department of Health and Human Services does say that the changes that we just covered are considered a material change to the notice of privacy practices, and therefore the required renotice, if you will, of all patients and everyone that's involved in this needs to happen. So what does that mean? Now for health plans, they have 60 days. So keep in mind that they actually have a hard and fast deadline to get things done. You, on the other hand, as medical professionals and other healthcare entities actually have a little more flexibility. And in this, you have the opportunity to make the notice available upon request, just like you do today, on or after the effective date of the revision. Then you need to have the notice available at the delivery site. So again, basically you can get a photocopy. For the ones that you have available, oftentimes offices just laminate it. But the one big one is that you need to post the notice in a clear and prominent location. So this is going to be the pain in the tush. Not only are you going to need to revise your notice, but you're going to have to make another big chart of the notice and post it up with the revisions. I don't think this is something that you could just go ahead and do some little pasty notes on. I think that, again, this is probably going to be something we're going to end up having to reprint it, which is a bit of pain. So what do you need to get done by September 23rd, 2013? I've got your homework here for you, and then I've just got a couple questions for those that are live on the line. The first item that you need to do is you will need to revise your notice of privacy practices. Obviously, you'll need to go in those areas that I highlighted for you. You'll need to go in and make those changes to your notice. The second one is you're going to need to make copies of the notice and post it to the website if you've got your website and you have it out there. So think about that. It's not just making the copies. The second part, too, is that you need to go ahead and post it, as I said, in a prominent location. But the two parts too that, again, it's about this implementation is go ahead and make sure you're training your front staff on the fact that you did revise the notice and that they need to make sure that they tell the patient about it. So it's not so much that you've got this passive, hey, you know what, it's posted up there, we've got the revised. There needs to be something more. So not only maybe it's a signed revised notice of privacy practices, but again, when they're doing that front office interaction with a patient on intake, that they need to go ahead and say, you know what, we just revised our privacy practices. If you'd like a copy, here it is. This does not require a new authorization. So again, for any new patient, you are going to have to do your authorization of privacy practices. And if you set up that they're on a, say, a 2-year rollover, whatever you have set up for your patients to do reauthorization, that's still going to be around. But at the end of the day, you don't need to get a new authorization for these revisions. So at this point, if you've got any questions, please go ahead and put those into your chat boxes. And at this time, while I'm waiting for those, I do want to go ahead and take a quick poll here. So my first question for everyone is whether or not they are posting their notice of privacy practices on their website. For those of you who are listening on podcast, this is not available on the website. And for those of you who purchased the the video version, this is not available either. This is the benefit only of those that are available on actually participating live. All right, so it looks like a majority of you do post it on your website. I will share the final results in the handouts that will be distributed to you directly. So I'm going to move on to my next quick question for you. It's really who's going to be in charge of writing this. Since I am such a geek and an attorney myself, I love writing all of these crazy things. So I wanted to get an idea if you're planning on doing the writing or if you're going to pull in legal counsel. There's a funny note in this rule actually where it says it should only cost you $24 from your attorney to get this revised. I'm not sure if I'd go and say that it would cost $24 because likely it would cost more than that for my billable just to read yours. But again, it's a funny comment. It looks like, again, a supermajority of you do plan to go ahead and make these changes. I do think that, again, this is pretty straightforward and obviously love for you to involve your counsel where necessary, but likely is an opportunity for you to get more engaged. All right, and my last question for you real quick here is how do you document your authorizations? Because, again, this is going to be part of it. It's going back and looking at your authorizations and also for your new authorizations. And so the questions here that I've asked is if you keep a paper copy or if you scan them. And it does look like right now a majority of you do scan your authorizations. So it does look like while we were doing our polls, a question did come in. So let me open this up here. All right, so the question is, if you never see the patient, because again you're a pathologist or let's say an anesthesiologist where when you see them the patient is not actually really awake, how do you deal with this? Again, if the practice is separate from the hospital. Well, there's a couple things that you can do related to that. And again, I think pathology is a really interesting issue when it really comes down to how do you coordinate sharing the information. So what they've said is that you can rely on others that, again, are either taking the sample or, again, in the instance where if you're only doing the, let's see, so if you're only doing the read, you can actually be a business associate. But let's say it's for an individual, let's say an anesthesiologist. There you can rely on your business partner, who's the hospital, to coordinate the signing of that paperwork for you. You can also work with them to have a HIPAA notice that actually covers multiple entities. But there's some ways that you can coordinate doing that with your business partners. But in the instance of pathologist, it's one of those, if you're doing both the professional and technical on that one, again, you need to work with your client that's collecting those collecting the samples to go ahead and have a HIPAA notice of privacy practices that's both for you and for them. The other thing, too, and I covered this in our previous webinar, was related to business associates. And then there are some instances where you may be able to work, again, Medicare doesn't necessarily do this, but in your private insurance companies where you can be a subsidiary or a contractor. And in those instances, you'd be a business associate that would fall under the same regulations and requirements of a covered entity. Again, we covered this in a previous webinar. As of September 23rd, you'll have the same requirements. So that's a long story of working with your business partners and looking for opportunities. There is some flexibility, but to the questioner, I'll follow up with you directly because that is pretty complicated. So just quickly, we are 1 minute over. If I see no other questions, I appreciate all of you being able to join us today. Again, if you do have questions, you know how to get in touch with me. So with that, I hope you've enjoyed today's presentation. As you log off, please take a moment to complete our survey so that you can give the feedback on how I can improve these ongoing webinars with both quality content and topics that are relevant to you. Thank you so much for joining me for this 15-minute education program. This concludes the presentation. You may leave the meeting and hang up.